In this criminal writ petition, challenge is to the judgment and order dated 1/11/2022 passed by the Learned Additional Sessions Judge 13, Nagpur, whereby the Learned Additional Sessions Judge dismissed the appeal filed by the petitioners under Section 29 of the Protection of Women from Domestic Violence Act 2005, challenging the order dated 23/3/2022 passed by the Judicial Magistrate First Class Nagpur. The respondent had filed an application under Section 12 of the DV Act and prayed for reliefs under Section 18, 19, 20, 22 and 23 of the DV Act. The petitioners are the non-applicants in the said application. In the said application, the respondent has narrated the facts leading to the filing of the proceeding under the DV Act. In short, it is the case of the respondent that after marriage for few days she was treated properly. After few months of the marriage, the petitioner number 1 started doubting her character. The petitioner number 2, who is mother-in-law of the respondent, joined them at the place of the service of the petitioner number 1, initially at Hyderabad and later on at Bangalore. The petitioner, according to the respondent, took custody of her Sridhan. They refused to hand over the same to her. The petitioners, according to respondent, ill-treated and tortured her. She was subjected to mental pain and agony. The marriage between respondent and petitioner number 1 took place on 28/2/2008. In the year 2014, the petitioner number 1 got a job in USA. Petitioner number 1 took the respondent and his mother, petitioner number 2, to USA. In USA, the respondent was subjected to mental torture and cruelty. At the time of birth of the daughter, respondent came to Nagpur. After birth of daughter, the petitioners did not bother to take care of respondent and the daughter. When the ill treatment and torture became unbearable on 24/2/2018, the respondent left USA and came to Nagpur. She has been residing with her parents. It is stated that the petitioners have not provided her maintenance, separate residence and other reliefs. They have also refused to return back her Sridhan. In short, it is the case of the respondent that she was subjected to domestic violence. The petitioners appeared before the magistrate. They filed two applications, 14 and 15. By these two applications, they challenge the maintainability of the application and the jurisdiction of the court of magistrate to entertain the application. According to them, the application under Section 12 of the DV Act filed by the respondent after 1 year from coming to Nagpur from USA is not maintainable in as much as the respondent was not subjected to any domestic violence during this period of 1 year. The petitioners further contended that the alleged domestic violence was caused to the respondent in USA and therefore the application filed by the respondent in the Court of Judicial Magistrate First Class at Nagpur is not maintainable. The Court of Magistrate has no jurisdiction to entertain the said application. Para. Learned Magistrate by order dated 23/3/2022 rejected both these applications. petitioners filed the appeal under Section 29 of the DV Act. Against this order, the learned additional sessions judge dismissed the appeal. The petitioners are therefore before this court. I have heard Mr. Abhishek Verma, learned advocate for the petitioner, and Mr. H. R. Gandhi, learned advocate for the respondent, perused the record and proceedings. Para. Learned advocate for the petitioners submitted that, in view of the fact that the alleged domestic violence was caused in USA and the application was filed in the Court of Judicial Magistrate First Class at Nagpur, the provision of Section 188 of the Code of Criminal Procedure would become applicable. Learned advocate submitted that, as per Section 188 of the CRPC, previous sanction of the central government was necessary to inquire into or try such offence in India. Learned advocate submitted that, since the allegations made in the application may constitute the offences under the Indian Penal Code, and therefore the sanction of the central government was necessary for filing the proceedings under Section 12 of the DV Act in terms of Section 188 of the CRPC. Learned advocate further submitted that, undisputedly, for a period of 1 year, there was no cohabitation between the petitioner number 1 and the respondent, and therefore there was no question of domestic violence to the respondent at the hands of the petitioners, and therefore the proceeding under Section 12 of the DV Act seeking multiple relief under the DV Act was not maintainable. Learned advocate further submitted that the Court of Judicial Magistrate First Class at Nagpur, in view of the undisputed facts, will have no jurisdiction to entertain the application made by the respondent. Stop.